Becky McCurdy. Here. Chris Corey.
Here.
Jesse Pruden. Ali Horowitz.
Here.
Russ Wynn. We know he's there.
So we have a quorum. Can I have approval of the minutes for June 10th?
So moved. Second.
All those in favor?
I'd like to make a change if I could.
Oh,
Just it's a very minor, ridiculous.
that's all right.
But where at 457, it says, Ms. Craig making a motion to keep Idian's less changes, stating less changes. I'm pretty sure I would never say less changes. You could say fewer changes or less change, but one or the other. The old teacher in me won't let that one go by.
All righty. With that change, can I have a vote? All those in favor, aye.
Aye.
Aye. Opposed? Thank you. Derek, are you?
Yeah, I have a couple things, updates from our last meeting. First is I have attached, it's never been that intense before. I've attached the, a Commission on Ethics opinion from 1978. And really this is going towards one of the areas that we've discussed, which is the changes we're making to Section 56. And I'm not suggesting not making those changes. What I want to do is, the question came up about financial disclosures for people who make campaign contributions. I contacted the Commission on Ethics. They gave me a number of opinions. They all sort of route back to the same issue, which is starting with this opinion 1978. They basically look at, they do not believe that there is a special pecuniary interest, which is the provision prohibited under the Code of Ethics, saying if you give someone money for their campaign, that is not the same as like a business transaction where you're not required to conflict yourself out. There is nothing though that prevents us from making that a disclosure requirement when they're voting on something. So if you had a quasi judicial item and someone at a developer had contributed towards a campaign, or maybe a neighbor who was opposing the project, they would make those, I propose in Section 56, those same disclosures as they would for ex parte communications and other things. The only difference was they would not be excluded from voting, but they'd have to make those disclosures as a matter of record. And so I think that was trying to address one of the issues that Board Member Corey asked for. And so I think, please take a look at that language in 56. Ask me if you have any questions on that. The other significant change I made that you haven't seen before was Section 24. And as you recall, this was the going from 12 to 48 hours. And I wanted some direction regarding emergency provisions. And so I think I've come up with language to that effect that I believe covers everything that was asked for. So it would be 48 hours, not exclusive of weekend hours. So basically, if it was 5 o'clock on a Friday, it only calculates till midnight, and then it starts back the clock Monday morning at midnight and runs till you get to 48 hours, with an exclusion for emergency scenarios. And so I left 12 hours notice. However, the council shall be limited to taking action solely to address the emergency situation. So in other words, they can't vote on some, procurement policy or make changes to something else. It has to be directly dealing with that emergency. And I didn't necessarily want to limit to only natural disasters, because there could be, localized emergencies that meet the emergency requirements but haven't been declared by the governor to be a state of emergency. So I didn't want to limit it, tie us to those issues, or tie us to something that may be a county emergency. It could be an environmental emergency, anything like that, but the actions
What
taken
about
would be
waiting? Do you have to wait 12 hours if there's an emergency? That's what I couldn't get that. Say you have something that just happens, a hurricane, and you have to declare an emergency.
Generally, so the public open meetings requirements require reasonable notice. The Attorney General has opined that reasonable notice is 24 hours. We took a fairly less restrictive view with the the city's charter by saying 12 hours. There's never been any holding or anything to rely on 12 hours. But I think the idea was 12 hours would be reasonable for almost any emergency situation to get the council together to take action. Anything less than that would have to be taken by the city manager.
Oh, good, she's here during the hurricane. Okay,
Well, a hurricane is a good example. Even when it's anywhere remotely close, everyone declares a state of emergency, whether it hits
Then
us or
wait.
not. I'd be more concerned about like wildfires out east or something like that would be more of a.
Yeah, that was kind of my question, is declaring a state of emergency, is that kind of a term of art that has specific meaning as opposed to just, identifying an emergency that might not qualify as declaring a state of emergency, or just wanting to have a meeting to discuss an emergency to decide if you want to declare a state of emergency? Or I just didn't know if you used that particular language specifically because it had an objective standard to meet. What was the thinking?
The closest objective standard is in it's chapter 257, the emergency management powers. The state lays out that during a state of emergency, both the state and local governments can waive procurement rules and other technical, basically, and I remember Hurricane Charlie, we broke into a Publix and raided it for all the water supplies. Things like that are the things that are given. But those generally will not kick in until there's been a statewide declaration of emergency. The statute doesn't work, but I tried to mirror the language as close as possible. So declaring a state of emergency rather than saying there's an emergency. Because, it could be an emergency that a contract is going to end tomorrow. And I think, based on Councilmember Perdon's comments, he didn't want those kind of things coming up as emergencies.
Madam Chairman,
yes, Barb.
here. Might I ask a question?
I was.
Oh, I'm sorry.
I know I'm kind of way down the end here, but just a question. Not the emergency, but up above we talk about exclusive of any weekend hours.
Mm.
What do you do for a 3-day weekend, like a holiday?
Labor Day weekend.
I believe based on the comments we had at the last meeting, we were only talking about weekends. We weren't including 3-day weekends in that. I thought I'd ask for the clarification on that, and I believe based on Member Perdon's comments, he wasn't including like bank holidays and things.
No, I don't think he was.
So I just stuck to standard weekend hours and didn't put 3-day weekends or holidays.
Okay.
Because then we'll get into a whole, who recognizes, do we have our list of holidays, the county's list, the state's list,
Does that mean
full
that
days?
48 hours might be up so the meeting could be held on the holiday?
I suppose it could be.
So if it were done Thursday at the end of the day and it was a Monday holiday, you might actually have it. Okay, just so we know that that's a possibility.
Well, they don't have to have it.
No, they don't have to, but I don't know if Columbus Day or something like that's going to be enough to
And I doubt that.
keep people away. In fact, it may actually mean there's more people available to show up because they're not working.
Okay, any other?
No, other than that, we made all the other changes that were requested. 2 other items that were discussed were looking for greater or other examples of restrictions on the assistant city manager and like assistant city attorney positions. I haven't been able to find anything like that. There's not really a database where I can search everyone simultaneously without asking around, sort of hunting and pecking. So I didn't find anything where that was specifically called out. I did find several ethics codes, not in the charter, but ethics codes where those positions were listed for local reporting purposes, but nothing specific to those comments. I think we would be, if we want to include those positions in those in the restrictions, I think we can do that. I don't know that we need any additional language to do it. I think just need direction from the committee to do so. The other comment was with respect to Omer's inquiries as to what economic analysis were done for cities that changed their names. I looked into 2 of the cities that he mentioned, which were Dania and Hollandale. both cities changed their, names by charter amendment over 20 years ago. And neither city had the original studies that were done. Once the City of Hollandale did have a study at some point that was done. So I tried to do some basic research on economic benefits through looking at their Tourist Development Council and looking at their property values to see if those changed. Unfortunately, we're talking 2000, East Coast Florida. All the property values were
Yeah.
changing, all the tourist revenues were going on, and it was very difficult to peer into those two cities because, in particular, they both had hotels that came on afterwards. So their bed taxes went up, but the hotels were built well after the name change. And those two cities, I would say, did not track as well as their neighboring cities for redevelopment. So their home values, their property values went up, but they did not track as well as some of their neighbors, like Miami Beach and City of Fort Lauderdale and City of Hollandale. Hollywood all went up a little faster than those two. So it's I'm not saying that it didn't change, but
Possible to find a causality connection.
Yeah,
something like that.
that's
There are
really.
Zillions of other things.
I believe Meg is still looking
Yes,
into
so-
another city.
So the city of Lake Worth in March voted to change their name to Lake Worth Beach, but that was March of this year, if I'm correct. And the news reports say that they have not yet determined the economic impact as well. They're going to be studying that, but they have not yet determined that. And it looks like they brought it forward in an ordinance change with an agenda item before their council, but there wasn't a study. We requested a copy of their agenda and item that went forward and the ordinance, and there was not a study attached with that, so we're waiting to see if there's any more additional information, or also reaching out to their Chamber of Commerce to see if they have any related information to that as well. That was the only other city that we found that recently.
Oh, that's fine. And we can wait for that. I mean, they're doing it right now, aren't they?
In March of this
Yeah,
past
but I
year.
mean,
Yeah.
it's,
I'll admit that I did not realize that Lake Worth was on the beach.
they what?
I didn't realize Lake Worth was on the beach. There's some benefit, right?
I didn't know it was,
I thought it was west of 95. I also about 3/4 of the way through, and I'll send out before our next meeting. I already proposed questions for the referendum, because you asked me to see if I can get that to you as soon as possible. So based on the changes that you've already approved, how those referendum questions would be asked. I've already started working on that.
very good.
And would that include also how we would explain why that change
Yes.
is needed? Okay, so the wording would be both. That's what I.
Trying to do is small. You will certainly want to make your own changes to it. I'm trying to just get the ball rolling for you.
Can I?
Yes.
Thank you. I want to go back to section 56. And I think it's really to not only promote good business practices in the city, but it's to insulate the council members from trying to be influenced by people who have business before the city. And in that regard, I pulled the City of Jacksonville, Florida Code of Ethics.
Okay.
And let me pass those out.
Thanks.
So that everybody's. If you could- And I know that we got caught up on contributions and so forth, but the problem I have is with the appearance of council people rooting or supporting or sponsoring or whatever you want to call it, plans that a developer may have for a parcel of ground that's under the control by the city. And so in taking a look at the city of Jacksonville, I'll read a couple of paragraphs that I've highlighted in red. That it's an offense for officer or employee of the city or an independent agency other than the proper discharge of his or her official duties to act as agent or attorney for anyone before any unit of government in connection with any preceding application, request for a ruling or other determination, contract, claim, controversy, charge, accusation, arrest, or other particular matter in which the city or an independent agency is a party or has a direct or substantial interest. And then subsection 3, to act as an agent or attorney for anyone before any unit of government in connection with a proceeding, application, request for a ruling or other determination, contract, claim, controversy, charge, or other particular matter with respect to which he or she or a unit of government of which he or she is a member has acted upon in an official capacity either before or concurrently with his or her acting as agent or attorney. Now, it's interesting what defines an agent, which I've included on page 3 of the handout. And there's several different definitions of an agent, but one of them is an agent with apparent authority. Apparent authority, also called ostensible authority, exists where the principal's words or conducts would lead a reasonable person in the third-party position, that being the city, to believe that the agent was authorized to act even if the principal and purported agent had never discussed such a relationship. And that's where I fear we have a problem, because the appearance of a council member acting as an agent when he's speaking for developers with respect to particular projects that come before the council. What I would like to see is that the council members themselves are insulated from the developers, and that they are there in once it goes through the community development agency, when something comes up for approval at the council meeting, that the council meeting acts in a quasi-judicial manner and does not have previous discussions or relationships with those developers. That includes ex parte communications, that includes meetings with those. In my view, the council should have, be as pure as Caesar's wife when it comes to making these decisions. So that's my concern.
So I just want to try and clarify, is your concern that in having discussions with developers or their agents before quasi-judicial hearing, they are then acting as agents for them?
Well, I don't think they're acting as agents in that particular case. But when they become advocates for developers, whether it be in city council meetings or before CDA or whatever, then I think they implicitly become agents.
But you don't mean in a sense that they're actually, because I'm unaware of any council members who are like paid consultants, not like stepping off. You're not saying they're stepping off the dais, coming and representing an applicant. They're saying they're just in favor of a project, that form of advocacy?
Well, they could be the primary force or the primary sponsor of that project before council. Or they could have been the one that added the particular item to the agenda for that meeting. And all I'm saying is that it gets back to how do you want to insulate council members from developers, for example, or anyone seeking a contract, where that council member has to sit in a quasi-judicial hearing meeting and make a judgment as to what's in the best interests of the citizens of the city.
I don't see how you can separate them talking from developers. This is a small town. Most of them know everybody. Everybody talks about what's being developed. I don't see how that makes, if they convince me, say I'm going to be on the council, and they convince me that it's a good project, what makes me his agent when I'm going to vote for it on the council?
I'm not saying that you would be an agent at that point, but
Or-
where you may be saying things to push their agenda forward with respect to CDA, or where you're in conversation with other council members and you're suggesting that this might be a good idea. So on, I think you become an agent at that point, where you act as an advocate or as a sponsor or whatever you want to call it for that particular project. I think you have to stay neutral on that thing. It would be no different than say an appellate court judge, listening to the arguments of the attorneys in chambers without the other parties being present.
Well, when I was in the legislature, if somebody would come to me and present a project, let's say, and I liked it, you wouldn't expect me to go talk about it to other people in my delegation?
Could I maybe speak to that? I think that you're talking about apples and oranges there. You're talking about a legislative exercise of power. And when the council is acting legislatively, I don't think that's any problem either. But I would just point out that already, if you're in a quasi-judicial hearing, you are supposed to not be talking to other members of the council about that hearing, that is prohibited. That's not one of the things you're allowed to do. Or am I on the zoning board allowed to talk to other zoning members when we have a case before us? So I think that...
Are you allowed to talk to the developer anytime?
I am not on the zoning board as it currently is constituted because we voted unanimously to not do that. The council of the city of Bonita Springs can at the moment, because they have not voted, and that was one of the proposals we discussed, as to whether, if you're going to speak with somebody who has a quasi-judicial issue before the council, whether you should have to have someone else with you, a member of the staff.
Right.
The problem being that when you talk, when nobody is there, nobody knows whether any promises have been made or any agreement to make some change from the council
Right.
that would make the proposal go through better. So, though I'm sympathetic to everything you had to say, I'm not sure how adding anything is going to make it any easier to enforce what already exists. We already say you're not supposed to do that, and yet we all know that it goes on with the developer. I am assuming, although I certainly don't know this, but I'm assuming that the council members respect the requirement that they not talk with each other before the meetings and sort of see if they've got the majority to do what they want to do. But I have no way of knowing that, and we have no way of policing that, so I don't see how putting something in a rule that you can't police is going to help. It's my general feeling that we ignore too much of the law already, so we don't want to put in law something we know we're going to ignore. We should put into law something we know we can enforce, and then you're making law that is respected. And I don't see how we aren't able to enforce it as it exists. I don't know how we could add to
Could
that.
enforce this.
Well, I want to kind of clarify too, just so that there's not a misunderstanding as to, and I know that Ms. Craig understands this, but the zoning board is not legally prohibited from having ex parte communications. If they have them, they have to disclose them. They have voluntarily agreed that they will not meet with any developers, and that has not prohibited citizens from submitting usually written comments. They're not meeting with citizens either, but at the last meeting, we had to disclose that everyone received packets of emails. And as we discussed at the last meeting, it works both ways. And so I think the issue is not so much the concern that I see many councils having, especially smaller communities, where maybe they don't even have zoning authority. They may have delegated that to other, like hearing examiners like they did in the county, is if you're going to prohibit the conversations, the communications with developers, you also have to prohibit the conversations, communications with the residents.
With what?
With the residents. You can't have, so to Mr. Corey's comment, he's right. It's like saying not having the prosecutor having access to a judge, but not the defense attorney. Well, you can't also then say the defense attorney can have access, but not the prosecuting attorney. Unfortunately, it has to work both ways, and I think in small communities, single-member districts, that's a really hard sell for the council to say, I can't talk to you about this big thing that's happening in your neighborhood.
Well, how would you ever learn about it? I mean, the goods and the bads about it,
Well,
pros and the cons.
in theory, the idea is everyone is talking at the
At the
quasi-judicial
hearing.
hearing. And if there's been communications, it has to be on the record ahead of that meeting so that either side can challenge that perception. So if, it almost never happens, but I'll say that, we'll say councilperson X has lengthy communications with the developer. Well, a resident or an attorney representing the residents neighboring the project are fully entitled to cross-examine that member as to those communications and determine if there's been an impropriety, if there's been some bias, and if they do so and they establish that bias, they've established it on the record. So that's the purpose of the disclosures. So the only language I've put in so far has just been language to say financial disclosures for campaign contributions. You know, those would also be disclosed so someone could raise that as an issue of bias. But if that's not where the intent was, I'm happy to take adjustments on it. But I think the issue of whether or not you want to completely preclude quasi-judicial communications, that's a different matter. We can add that if that's the desire of the committee.
Well, Arlene, isn't there a process already pretty well laid out for developers to present plans to the city or a development that they want to do?
So the Land Development Code prescribes the rules and regulations of an application being submitted through a community development process. It has deadlines and dates, and it has submittal requirements as well. And then those, depending on what type of case it is, if it's going to be reviewed by the zoning board, all of the application with all their submittal plus an analysis by the staff is presented to the zoning board, and then subsequently to the city council upon their review. So there is a process as to when applications are heard, similar to our process. Our original Land Development Code process was set up the same as the Lee County Code, except for the fact that the Lee County Board of County Commissioners elected to have a hearing examiner who makes the final decision, as opposed to a zoning board and the city council and the county commission in that respect. So there is a process in place. I think, too, some of the concerns that have been listed before is that citizens may not always have the expertise of their attorneys, engineers, and planners who are in these one-on-one meetings advocating the position. But citizens do probably have a little bit more opportunity to run into their district manager or have that one-on-one conversation. So there's advantages and disadvantages to both sides when they're asking for access to have a discussion with their council member. But all of which, even those preliminary stops in a grocery store where questions happen, all are to be reported within the disclosure statement.
And the process is laid out so that if you are a neighbor or you drive by, you either see it in the newspaper or you see the sign posted on a property or you're within 500 feet and you get individualized notice. That notice doesn't say, go knock on your council member's door or send them emails. There's going to be a public hearing with anyone interested in this proposal is supposed to come to the public hearing. So you're also asking a lot for the residents to be educated as to why they're not allowed to communicate with their elected members.
And if I could comment once about that too. And therein lies the problem. There is a real difference in expertise and knowledge of the system between the developer who's coming before the board and the citizens who might want to have input. And so that and the developers know that in the city of Bonita Springs, there are certain council members and there are certain who will not. But there are certain council members who will meet with them ahead of time and have these discussions. I don't think the citizens know that at all, and the only way that happens is if some group of individual leader emerges and says, write your council member, here's the important issue, here's why it matters to you. But still that balance is really off. And so I'm not 100% certain. I understand in the quasi-judicial context that you're not supposed to do that. But since I also know that our zoning board and our council quasi-judicial process has some of the elements of a law, of a court, and many not,
Hence the
th-
quasi.
many not, that you probably could make an argument, a reasonable argument, to say that since citizens don't have that expertise, are highly unlikely, and the other party is always going to do that or always going to try because they have that there would be some sort of exceptions or slack made for citizens being able to communicate, at least by email, with their representatives. It's the only way they'll get anything in, and we already know the developers are getting stuff in ahead of time, so, except not with this zoning board, for which I'm very proud.
So, I mean, basically, the developers know that one way to deal with what they want to do is to simply make appointments with city council members and discuss the projects with them, the pros primarily, maybe not so many of the cons, but the pros as to why it ought to happen. And so they're, you know, the process that Arlene has laid out, with going to CDA and the steps involved in getting a project approved, you know, they tend to go around the block to the other side and say, you know, this is going to be coming up. I want you to be familiar with what this project is, and then they go through that whole thing. And I just think it's, you know, this is nothing new. I mean, I'm not totally naive that this hasn't gone on for hundreds of years, but I mean, to the extent that a lot of cities are able to, I think, Jacksonville, Miami-Dade, sort of put rules in place that say, look, if you're going to be on the council, you need to tell people in these situations, we're going to let the process work within the city as it's been designed and laid out. Everybody, if you don't know what that process is, I'll be glad to explain it to you. But I'm not going to be part of trying to listen to all the arguments which you're going to present or the developer's going to present prior to the time that it comes up as an agenda item on the council's part. It's just, you know, it's just trying to, I mean, to say that it's going to happen anyway, therefore we shouldn't, we can't regulate it, doesn't mean we shouldn't try to at least have, you know, it's one small step. This is going to be
I'm not suggesting you can't
city
do
of
it.
Well,
60,000 people.
And this will be discussed with the council. So,
But I think, you know, the issue is, it's a policy decision. So, I mean, your recommendation, whether it's to go towards a ex parte prohibition or not, it's your recommendation.
Right.
You know, I can tell you the closest city who's going to it right now is Cape Coral. They haven't done it yet, but they're setting the groundwork for it by setting up a hearing examiner. So that in Lee County, what happened over time, why they went to the hearing examiner process was, well, now you have 600,000 people plus living in Lee County. In Jacksonville, it's over 1 million. Miami, it's 300,000. The big cities, you could very easily get overwhelmed with the amount of people who want to talk to you and pull you in 50 directions. And when you have that level of input, and you need to make sure that those decisions are following preset requirements, those cities have moved towards a process where there is effectively a judge who rules on those, makes final recommendations, and then if there's any action that goes beyond that judge to the council, it's in the matter of an appeal, or it's in a very limited form where they don't take any new evidence. So in Lee County, you can appeal a hearing examiner decision, but the public and everybody else is limited to only the record below at the hearing examiner. They can't add anything new. And so the commission there is very clear that when people come up to them on the street, I can't talk to you about this because it's not my decision. And if it's a decision, we're only appealing the issues and facts and legal arguments made at the hearing examiner. Now, the Cape has just recently gone to a hearing examiner process, but that still is a recommendation. It's still a free-for-all when it gets to city council, and I've sat through a bunch of their recent free-for-all. They will probably end that at some point, but they have 200,000 people, and so that's that's a big difference of the number of emails and stuff to actually be able to make a decision. So, again, there are not many cities in the small side that do this, but there's nothing to prevent you from doing it. So it's really your recommendation. If you want this to be something to either consider or to go with a recommendation, just let us know and we'll put the language together. But I mean, it's not something, what I'm not saying is,
Well,
I'm
I
not saying
think
you
if
can't do it.
If you put the language together for the next meeting,
Okay.
then we'd have a better idea of how it all goes. Is that all right with everyone?
I
or
think that's a good
John?
idea.
Yes, I think that's fair. I will say, though, I share some of the concerns that have been expressed here, and also the notion of when you're trying to draft some language here, this, the legal definition of an agent, cloaked in apparent authority. I think we're opening up another can of worms with that, as opposed to someone who is clearly the agent or attorney for a developer or another third party. I don't see how that works in this context, so I would just
I'm
ask you to
thinking-
think about
Yeah,
how
the-
you're gonna draft
The
that.
language I'll come up with will be just a strict ex parte communication on any quasi-judicial matters. So, no staff, no applicants, no neighbors. No one can talk about the issues. And then probably some form of disclosure should something inadvertent come out.
Good.
That's the only realm you have range to move on. I don't think you need to make an analysis on whether there's an agency, because you're not allowed to talk to anyone. The biggest issue will be, I think, and just for you to think about, and I'll see if I can get some backup materials to send you on some of the case law, just so that you can familiarize yourself with, will be the requests for information. How does the council get more information than occurs? How do they get opinions when they can't talk to anybody?
Barbara, do you want to say something?
Yeah, well, I was really concerned about that when you said staff, as to what exactly that meant, because if you need more information when you're reading a packet in order to be able to understand something, you have to be able to go to the legal counsel or to the experts in the land use department to be able to get the answers you need. I was also a little concerned about that, is how that would affect the public, because the developer, in the process of applying for a proposed development, can talk with the staff. In fact, they have to talk with the staff. So I would assume that during that process, it would also be proper for citizens to talk to the staff.
It is.
Yeah, I mean, so that there wouldn't be any. So I was just a little concerned when you said staff in there, that was clearly accepted.
I think that the citizens are able to submit their concerns to staff, which is then part of the packet that's provided in the overall hearing process.
And just to make one more comment, we added a new layer in this process recently, and that was that the developer is required to hold a neighborhood meeting prior to the final proposal, and then is required to have everything said in that meeting recorded and react in his proposal to those concerns that have been raised by citizens in the neighborhood meeting. And we've actually seen some of that, I think, work at our zoning board, where specific concerns of residents about issues have been addressed by the applicant before they came. And so that was, I remember, I'm terrible about names, the attorney for the planning department, what?
Oh, David Theriak?
David Theriak, I couldn't,
So
his
yes.
name wouldn't come into the frontal lobe there. David Theriak sort of said that this, he thought, was a very important and critical change to our process, and that it would perhaps get rid of some of the contention, because many things could be worked out ahead of time. And I mean, I actually have seen some of that happen. Sometimes it doesn't work, but I think that's a
No, it's
positive
good.
step.
Good to try.
You have 2 required meetings, once prior to the application submitted, then once prior to you going to the zoning board, I believe. Do you have a time frame of the time of when the application is advertised to be heard by the board, to hold a second public meeting, and to record those comments received from the community at that point as well, and bring that forward with your package?
So we will have that at the next meeting. John?
Just one question about the language in 56 that you already drafted. It's just a timing question, and maybe this is taking too deep a dive into a charter document, which
Right.
can only hit the highlights, but just a timing issue. When you talk about
How do they know?
campaign contribution, I mean,
Right.
I might have run for office 20 years ago and didn't get elected, and then subsequently did, and, you know, is there any sort of time frame? Do you have to disclose things like that? I don't, is it just the
Okay.
the past election
Prior
cycle?
Yeah.
You know, just a thought on that.
No, that's good. Anything else on this? Are you satisfied with that? Good. Okay.
Is there anything else that you want to revisit, have any discussions on?
Madam Chair?
The only,
Yes,
oth-
John.
Oh, yes, the
Section
blue ribbon.
62.
Section 62.
I mean, this was the language at last meeting. I wanted to defer until we all had a chance to kind of take a closer look at it. And I think this is Mr. Purden's, some of his concerns are addressed in here, so it's unfortunate he's not here, but I have some concerns with parts of what's in here. I think parts of it work for me. Some of it seems to me to be probably not consistent with the First Amendment rights, and it concerns me that this, we had some conversations. I know we were trying to target maybe the city manager and some of the senior staff, but this seems to limit in a significant way some of the rights of any employee of the city, including having to leave the city's employment in order to run for office here. You know, so I mean, I don't know how you'd like to address that. I can mark up what's here and for the benefit of the rest of the committee and circulate that through staff. I don't know if you want to go through it sort of section by section and talk about it.
Well, maybe tell me, what do you like, and then what generally don't you like, and see if there's any other comments, and we can,
I don't know who's considered an officer, because we say an officer or employee, just to start out. So I'm,
the officers would be basically any of the senior staff, anyone in procurement, but,
specifically the charter calls out the city clerk.
yeah, I'm not an employee, but I would be an officer. So otherwise, if we didn't have certain contract positions, I'd say all employees, but that's not inclusive of everyone, so the officer was for myself and a few other people.
okay, well, I have a concern that this includes all employees of the city.
Okay.
And it reads, however, no officer or employee of the city shall hold or be a candidate for public office in the city while in its employment. Well, I'm not in favor of a provision that would prohibit a staff member from running for city council, or require them to quit their job in order to do so, or take an active part in political campaign. I think we're impinging on the First Amendment rights of the city employees to exercise their freedom of speech and support campaigns simply by virtue of working at the city. Take part in political campaign, organizational management, or make political contributions in support of a candidate for public office in the city. Here again, I think that employees are free to make contributions to a candidate, and frankly, I'm concerned about whether this is a lawful provision. After that, I think the language is acceptable in my view. In other words, they can't use the authority of his or her position to secure support for or oppose any candidate. So I understand that that's a distinction from the prior sections, and is something that makes sense, that you shouldn't be able to use your office to further a candidate. I'm not sure what "or affect the results thereof" in an election, or affect the results thereof. I'm just not sure what that language is meant to mean. And the last sentence, I think, is is reasonable. Neither the mayor nor city council member shall use or promise a reward or threat or encourage or coerce an officer or employee to support or contribute. So, I mean, I think that's one of the concepts that was being discussed here, that we shouldn't there shouldn't be a situation where the mayor or council can pressure employees to take political action. So I'm okay with that.
And I think the comments from Member Perdon has been directly related to something like the city manager being on the host committee for a particular candidate. Those were the basic circulations. I used the language, most of this language came from state regulations for state employees. That's not to say that it could not still be unconstitutional. You know, there's plenty of regulations that are until challenged. The last sentence, member, other mayors, there's already some provisions in the Commission on Ethics in Chapter 112 that prohibit that, but I don't think there's any reason for explicitly laying it out here. But maybe if there's direction to let Mr. Jenkins work with me on some proposed revisions.
All right, yes. And you'll have those the next time we come, correct?
Question, Madam Chairman?
You'll have those ready the next time we,
I will.
okay.
Question. Just curious, you talk about any city employee. Is there any way to restrict it just to the higher level?
Sure.
People, department heads, or, you know,
I think that's what's,
senior management, sort of?
I think that's one of the proposals that'll be coming along.
Good.
And I believe that comment was from Mr. Perdon himself at the last meeting, was he wanted to look at, but he had asked me to look at language for senior management, so that's probably where he was focusing anyway.
If I could just make one more comment, which I think I did last time, is that in the Hatch Act, that is very clearly the difference. There are different rules for general employees and for higher level employees. So it wouldn't be going against national law, and I'm pretty sure that's the same for state law too. So
There was one other change that, section, this is the,
So there was a request for some different additional information about the city of Naples and their pay increase policy, so we've included in that, in your packet as well, which lays out the procedure for the Blue Ribbon Independent Committee that discusses,
and I did incorporate a variation on that in the code. I apologize, I totally forgot it when I was looking at it, section 19. So they have their Blue Ribbon Committee. I put the last new sentence, or last two new sentences in section 19, from time to time, but in no event less often than every 4 years, the city council shall appoint an advisory committee consisting of 5 electors for the purpose of studying and making recommendations to the council on the level of compensation and benefits for the mayor and council members. If at any time the council takes action to change the level of compensation, the salary for the members then sitting on the council shall be adjusted beginning on the first day following the next ensuing regular municipal election. So I looked at their Blue Ribbon Committee. I didn't particularly like the language, and I just came up with this instead.
Madam Chair?
Yes.
One comment. I was fine with the language. In thinking about this, it occurred to me that it was not my intent that this be exclusive to the council's ability to otherwise adjust their compensation. I don't think that's a particular concern of mine, but I didn't know whether the committee had the impression, or others, that this might be an exclusive remedy for changing compensation. For my part, I wouldn't suggest that. I'd say in addition, any other, rights under the charter or state law, or however you would phrase it, but
Okay. I can make that change.
thinking about it, that was my only concern.
So may, not shall. So not constantly having a sitting advisory board, but sort of heavily implied that if you're going to be changing your
You
your
may.
compensation, you
Reality dictates.
have the option of putting this together. Okay.
Political officers rarely are willing to increase things. Nice way.
Okay, I can change that.
Okay. Anything else?
I don't think so.
Could I ask that we get an actual final list of when the dates are you want us to meet next? Because I kept getting all these,
We're going to do that
yeah.
right now.
We are? Okay.
That's the next thing.
Because I couldn't decide from all the emails exactly what was on and what was off. I got
There
confused.
is a list.
Okay, I'm writing it down.
Yeah, you don't have to write it down, you got it.
It's the last page.
The last page of the whole kit and caboodle.
Yeah. Okay. So this is,
So, yes, there are some items we wanted to discuss with you. We know that our chairwoman is going to be traveling a little bit, and we wanted to accommodate enough preparation also for the joint meeting with council. So we looked at having an August 1st meeting. That's a Thursday, so it's not a Monday meeting.
2 Thursdays.
2 Thursday, August 1st and August 29th. What we may be able to work towards a joint meeting on September 9th, and we're working on that. That also may end up being a date of our budget meeting. We're still working because we want to ensure, number one, that we have a full council to be able to be part of our budget meeting, but a full council to be in your joint meeting as well. We're trying to get as much attendance as possible. So that's what we're working through, which might be, you have on there the charter review public workshop, that if we do our budget, city council budget meeting that same day, that might be an adjustment we have to make for that meeting. But, so for your August meetings, we would be looking for August 1st and August 29th. And then we're looking to try to create the joint city council charter review committee meeting on September 9th. And we'll be discussing setting the budget meeting at our July 17th city council meeting. Right now, that is set for September 4th, but I am aware we won't have all of our council members available for that day.
Is that all right with you? Is it, Alan, is that all right with you?
I believe so.
John? Are those, the 2 dates in August all right with you?
I think so.
Barbara?
August is fine for me. You know that I will be away in October, so
Yeah.
here for the October meetings.
Fine. Then you're fine.
I think our hope is that the majority of all our substantial work will be complete by October, so that it's basically a first reading of the city council.
Right.
Oh, okay, so they just, okay.
Yeah, second.
Just the reading.
Very well.
Okay. Do we have any more, well, we might have more discussion items after the 2 things that you do.
Right, so what we'd like to do, that's why we built in 2 meetings in August, so that you have plenty of
Right.
time to, and I'd like at our August 29th meeting that we'd basically have a draft
That's it.
agenda for that meeting,
Good,
joint meeting.
Good.
That you could approve.
great. Very good. Okay. Yes,
Madam Chair,
John?
So did we include this name change on the list of things going to the council, or have we not
As
done
of right
anything on
now,
that
you
yet?
hadn't- you
We
hadn't-
had no vote on that,
had not directed us at this point.
and we were waiting to hear some things, and I guess we'll wait until he comes if he wants to. We haven't voted on accepting that. And we might have information next time on the one that they're
Lake Worth
looking at.
Beach. The direction was for us to bring back some additional information on the communities that had changed their
Right.
names, so we've done some outreach. As I said, March 2019 was the most recent name change, which was Lake Worth Beach. And we've gotten some copies of their agenda item and background material, so we'll forward those to you.
Well, Madam Chair, just
I'm listening.
regardless of what we find out about economic studies that other communities have done, to me, that's putting the kind of the cart before the horse. It's not clear, I know for myself, I would not be voting in favor of a name change as a recommendation from this committee. However, I would be interested in putting that on the list of items that have been discussed here for council consideration. So if that's any, we haven't really had a further discussion about the name change, but I really didn't know what the sense of the committee was on that. But if that helps give us any direction, that's certainly my view of it.
Well, I'm not for vote, not for the name change being on our agenda. But I was waiting to see, if there was more information that we had, rather than make it, because I think it would be the wrong thing to do at this time.
If I could just add to that, too, I can't think that seems more of a political issue to me. It's something that if it's going to come, it ought to come from the council or come from the people and not from a group of appointed people.
Well, it would come from the council if we put it on the list of things to be discussed, and then they go one way or the other.
That's true.
I can't imagine that there's anybody currently at the meeting that would be in favor of this suggestion. Would it be out of line if I make a motion that we table this topic?
I think it would.
Okay.
I think it would be out of line, because the man that proposed it and his advocate, I guess, maybe,
Okay.
is not here, and we've got the votes.
Okay, that's fine.
Okay. So I'd rather you not.
Okay.
Alan?
I agree.
Okay, good. Anything else that we should discuss at this time?
No, I thought we had a member of the public here, but
Didn't last very long.
Oh,
I think they got the wrong meeting, maybe.
he's a tree person.
Oh,
The Tree Advisory Board is meeting simultaneously there.
We'll have to talk about trees next time. We'll get some people here. All right, with no further business, can I have a motion to adjourn?
Motion to adjourn.
Second?
Second.
All in favor, say aye. Aye.
Aye.
Opposed?
Who's opposed?
Thank you.